Thank you so much, Andy, and thanks everyone for inviting me to be here today. Um, I think just as we get started, it's important to ground where I come from on this. I have never been a member of an MDT, not for any population, right? I come to this as a lawyer, but a lawyer who spends a lot of time with other professionals thinking about how do we do our work. And so everything that I do is grounded both in law and ethics, but also reality and humanity and group dynamics. It's interesting, Andy was talking about yesterday being the scaffolding of a team. And I like to think of this question as a bridge from the scaffolding to the doing. Because some of what we're going to talk about is actually homework for your team to think about how you're going to come together. And I often get called in when teams are struggling, when they have been meeting for 6 months, a year, 2 years, but it's not working. And I will ask some of the basic questions I'm going to pose to you today, and they can't answer them. And then I can say, well, I know why you're struggling because you don't have consensus on why you're here. So my goal is if you're in a team now and some of this rings today that you're like, oh, I don't think I know the answers to those questions. You can go back and work on it. If you're creating teams, then this is a great opportunity for you to get in front of things that could otherwise cause trouble later on. So that's my goals for this session. It's going to be a fairly fast romp. I also have a workshop this afternoon. We can do a little more discussion and deep dive. But I want to help teams identify the questions that need to get answered locally. And I want to highlight information sharing norms for professionals who are commonly on MDTs. Notice I use the word norms. I don't necessarily use rules or laws because how we think about the way that we use or protect information is as much about what we think is a good idea as what we think is against the rules or required. And then I want us to just sort of sit with how MDT information norms impact your group and how folks work together. And I came to these goals because as I've been doing this confidentiality work for 15 years, the questions I will get an email and says, I am on a collaborative team. Can I share this? Or can you tell me in advance what I can't share? Or I get why won't they tell me what I want to know? And actually, these aren't quite the right questions, right? I want folks to step back and start again, because otherwise, the way I would answer these questions is with that unbelievably annoying lawyer answer, which is, it depends. What does it depend on? It starts from your group. Like, what is your group doing and who are you? So the very first thing that any team needs to do to be able to answer questions about confidentiality and information is to have a consensus about who you are as a group. So I'm going to kind of walk through these 5 points, but the 5 points are, what is the purpose of the team? And I understand the global purpose, right? We want to eradicate mistreatment of elders. We want to address abuse. But what is the purpose of this team? Which leads you into the next question, which is, who is on the team and why are they there? What is their role on the team? I see a lot of teams making assumptions, so we're going to talk a little bit about that. Then, what is the law for the team? Lots of states do have some law around multidisciplinary teams, and so you need to know what that is. But what the law is for your team is a different question from what the law is for each team member who's coming to the team. And then finally, what are your norms and expectations around information sharing? Law aside, or law factored in, what does this group expect each other to do? Because by determining that, it helps you to figure out how you're going to work together. So let's start with the first one, the purpose of the team. So again, you might think, well, that's an obvious question, but not necessarily. Sometimes it depends on how the team came about, right? And I actually see this all the time. I do a lot of work with various anti-violence communities, and I work with domestic violence and sexual assault and trafficking and elder abuse and child abuse. And what's really interesting is on paper, you could say, well, each of those areas is about responding to someone in our community experiencing violence and harm. So they're all the same, but they behave differently. And a lot of times you can understand the different behavior by who sort of started the movement. Where did it grow up from? Or where did it come down from? Can start to help you understand how it thinks about its work. So because the nature of an MDT is to bring folks together from across different professions and communities, you have to articulate the purpose of the team. Why are we meeting? And I have genuinely met with folks who are saying, well, we met because we got a grant and we're funded to. Fair, but then make your time useful and make a choice about what the purpose of the team is. So is it to review individual complex cases? Is it to say, we're going to lift up the ones that are just like breaking our brains more than any other about how do we deal with them so that we can get multiple perspectives? Or are we trying to improve the systems generally? And is that why we're coming together? It's not so much about individual people, but it is about how do we see what individual people are experiencing as a way of improving the whole system. Are we facilitating referrals and getting needs met for individual elders who are experiencing harm? Are we increasing prosecution? Now, it's not impossible to have a team that has multiple purposes, but again, the team has to know that. You have to decide and you have to articulate. And I would suggest that you sort of have a lead purpose, even if there are other purposes you are also pursuing, because that is going to affect how you think about information, how you think about sharing, how the law sometimes sees what's allowed or not allowed, and how each profession thinks about what's appropriate or not appropriate. Okay. And put the questions in the chat. I'm going to make sure that we have time to do some Q&A. I love answering questions. Otherwise, it's just me staring at a wall by myself. So please throw things in there and we will talk about them. Folks on the team. Okay. We are going to launch a poll. And thank you. Okay. So what is the purpose of your team that you're on? I'd like you to choose all that apply. Review individual complex cases, systems improvement, facilitate referrals and meeting needs, increasing prosecution, or I don't feel completely certain. And that's a really valuable answer if it's true. And remember that I don't know who said what. So there's nothing about answering this that's going to call you out. I'm hearing from folks that only let you choose one. Okay, well, then I'm hoping you chose the lead one first. And thank you to one responder for feeling sad that it only let you choose one. Emojis are important. I keep thinking about how as a society, we're almost moving to like I'm not saying we're not literate, but a pre-literate space where we're using visual images to express complex emotions. I spend a lot of time when I'm trying to text my kids researching what an emoji means. Okay, so can we publish the results of the poll?
Alicia, this is Shelley. Can you
Yeah.
see the results?
I cannot.
Yeah, that's what I thought. Okay. So I would say the majority, the largest percent would be review individual cases. And probably next would be facilitate referrals and then systems improvement. Probably
excellent.
increasing prosecution, and I don't feel able to respond.
Are the least. Okay. Great. Look, I don't feel completely certain is a great, like being the least answered is great, right? Because that means you guys do have a handle, and that's going to position you to be able to work with your team in a better way to think about information. All right, thank you. Um, One thing I want to point out is that you can have one team, but your one team can have different kinds of meetings. So you can have different purposes. You're like, if you think about any, like the school board, right? The school board has public meetings. They also have executive meetings because there are things that they're going to talk about that might not be appropriate to have be public. Your MTT could also have some different meetings for different purposes. So that's especially true. And we're going to get into a little bit about how having prosecutors and law enforcement in the room has an impact on information protection that might not be appropriate sometimes. So you might, if you were having a meeting that is about coordinating somebody's case, then that you decide who should or should not be in that meeting. You're going to have a meeting that's really specifically about prosecution and how are we investigating this and how are we pursuing, then that is going to impact what gets said or not said in that meeting. So just think about the fact that the great thing about an MDT is it's flexible. And so it can allow you to use it as you need it. Think of it as a room of requirement for, folks who have read Harry Potter. Remember that the purpose matters. So if somebody led the team, if somebody created it and they had an idea in their head why they were creating it, then you have to know what their purpose is. If they're leading it and they're sort of in charge of it, then make sure you know what they believe the purpose is so that you understand what you're participating in. When new folks join, because you're going to have staffing turnover, you have to tell them, this is who we are, this is why we do what we do. You can tell them by having it written down. So one major purpose of an MOU is to describe who we are and what we're doing in a real way, not in a pro forma boilerplate way, but in a real way. Make sure new people get that information, and then have check-ins as time goes by to refresh your recollection. Right? Because I've been in groups who are like, this is why we're meeting. And then you're 6 months in and you're like, we seem to be talking about entirely different things. So it's a regrounding. Do we want to change what we think our purpose is? Or do we want to stick to it? And then are there any adjustments we need to make for that to work? If you don't do this, if you do not do the grounding, the deciding, and the reminding, you will be in a constant tug of war. And a lot of the tug of war will be an undercurrent in your meetings and then a grumbling back at your respective offices. So it's incredibly important, because this is then when people come to me and say, I don't like MDTs, MDTs don't work, I'm frustrated, we're struggling, we must be doing it wrong. It's really because you don't have consensus on the team about what you're doing or why. So one thing that's important is to determine if it's a healthcare purpose. So there are some professionals on your team, the healthcare professionals, if this MDT is defined as having a healthcare related purpose, then that might open up under HIPAA and state law what the healthcare professionals are allowed to share with the team. But it's not a healthcare purpose just because there's a doctor on the team or just because there's a nurse on the team. That doesn't make it a healthcare purpose team. And definitely if the team identified its purpose as increasing prosecution, that is not a provision of healthcare goal. So just be really careful, because I've seen this happen where there be maybe a doctor on the team and they're like, oh, HIPAA lets me share because I'm here, so therefore it's healthcare. But really, when you look at the MOU or who's leading it, it's really about facilitating prosecution, and those are different things. So you have to pay attention to that. Okay. So the participants on the team, who should be here? Who should be on the team? And sometimes if you're taking me up on my suggestion that you can have different meetings for different purposes, then it might be that the goals of today's meeting dictate who should be here. Or maybe you have a meeting of everyone, but then some folks are going to go into kind of an executive session. I will get to why that matters in a minute. But who should be here. We run an exercise written by my predecessor at the Confidentiality Institute, retired Judge Julie Field, and it's a sexual assault response team with many different professionals, and it's an amazing exercise because we give it to people at a conference and we assign them a role, and they start acting their social understanding of each professional role. What is a prosecutor like? What's a police officer like? What's a school nurse like? Um, and there are many people on that team that have no role in the moment. They don't know why they're there. They don't know why their profession would be there. And in fact, sometimes they have a conflict. And what we're really testing is we're asking people to figure out how to say, hey, I think I don't have a role in this moment, and maybe I have a conflict with the particular folks who are being considered today. I need to step out. How do we create space for people to acknowledge those things, especially in small communities? You really got to think about how are we going to handle this question of who should or should not be here. And then you want to know why people are there. So I work a lot with advocates. And what I find advocates saying is, I am on an MDT, and because I'm in the room, people think it is my job to tell them everything that the victim said to me. And I think maybe I'm not allowed to say what the victim said to me, but maybe because I'm on the team, I'm required to say what the victim said to me. And I say, do you have expertise unrelated to what this victim said to you? Do you have expertise in your profession about how victims behave, how they respond? Andy talked about, the trauma-informed reasons somebody might want to maintain a relationship with a family member who has harmed them. Do you have expertise about that? And advocates will say yes. And I say, well, does the team ask you about your expertise? And sometimes they'll say, no, they just keep asking me to tell them everything the victim said in confidential conversations. So you want to know why everyone's on the team. You want them to know for themselves, and you want the team to know why they're there, right? What their role is, so that you kind of, again, know what they might be doing or saying, or what you can reasonably expect them to share. See, and I predicted my next slide. I will say that this comes up a lot, although it also comes up, I think, for other professions, right? So I have colleagues who are prosecutors, and they're like, our team isn't designed around increasing or facilitating prosecution. Our team is really trying to find the universe of solutions. And so my role as the prosecutor is almost to educate people about our system and what the limits of what our system can do or can't do, and to just ask questions based on my experience of years of handling elder abuse cases. I've learned some things, and so I ask questions in a different way. That's why the prosecutor's in that meeting, not because they're working every case up for a criminal case. Okay, so it's extraordinarily important to make sure that everyone on the team has consensus about who is there and why they're there. And if you're in a circumstance where they're there because somebody politically powerful in your community assigned them to be there, okay, but you can still then come together and say, okay, well, what about this makes sense? All right. So that turns us to the question of what is the law for the team? So I think about this, again, my predecessor at Confidentiality Institute, Judge Field, came up with a really great rubric about thinking about information for groups. And it is what she calls the get, the got, and the give. So we're going to talk, this is really about kind of how does your team come to exist, and what law is there about the information that your team holds? So there is often law about MDTs. It's more common in child abuse MDTs because it's just been around longer, but you may also see it in the elder abuse MDT field, that there are statutes that will say what this team learns is confidential. In other words, what the team holds cannot be subpoenaed from the team. Now, it might still be able to be subpoenaed from an individual professional who got it in the course of their regular work, but you don't get to subpoena it just because the team heard about it. And Sometimes the law will give the team a bubble of confidentiality. I keep going like this because from the very beginning, when I started training on this, the only way I could think about it is within a bubble, within a circle. The statute, and I'm not going to try to teach you the statute because it's going to be different for each location where you're doing your work. If folks are struggling to figure out what the work is for their MDTs, then you can reach out. You can reach out to Confidentiality Institute for technical assistance, and we can try to help you find it. But also, you may have folks on your team who are very knowledgeable about your local laws and could pull it for you. But you need to know whether your statute creates rules that say affirmatively what this team knows is considered confidential. It can or cannot be subpoenaed, and the team can or cannot make these kinds of disclosures. And then also, does the team include any special rules for confidential professionals? So folks who are in their work, when they get information, it is protected by special confidentiality. Does your MDT law say to them, hey, here's an exception to your confidentiality. You're allowed to share with the MDT. Sometimes that happens. Other times it doesn't. Be cautious. I've had folks come to me and say, oh, our MDT says we confidential professional have to share with the MDT. And I'll say, okay, let's look at it together. And when we look at it, all the statute says is that we are on the MDT. And that gets back to question number 2, which is why is each person actually there? Don't assume that just because you're on the team, that changes the law about how you manage or protect information. I have seen some teams, and I've even seen some statute that do this, what I might call Vegas rules, right? So we all remember, like, one of the most successful ad campaigns ever, what happens in Vegas stays in Vegas. And I have seen some teams do an MOU that says, we agree what happens in Vegas stays in Vegas, or even a statute that says that. I would say be careful and thoughtful about that, because again, it gets back to the purpose of the team. So if you have a team that says, like, sort of, everything we talked about in this room has to stay in this room, then how are your team members supposed to use that information outside of the room? Is it, in order to achieve your goals, is it effective and appropriate for them to further share it back at their agencies? And I'm just going to say this, like, don't assume that the law that you're working with was thoughtfully written. I think sometimes these laws get written by folks who haven't been doing MDTs yet. And so they don't really have a sense of the nitty gritty and what might be tricky in practice. So sometimes the laws are overbroad. Sometimes, you might be trying to figure out what the words in them actually mean. Again, you can reach out for technical assistance or talk to the lawyers in your community. Maybe the folks who helped write and pass the laws can help you understand what they say and what they mean. But don't assume that your team has to have everything that comes into this team can only be here. Because again, if the goal is to use the information to achieve something, you need to think about how are you allowed to use what you heard at the MDT to achieve something. Also think about, what is the elder allowed to know about what gets said at the MDT? So I get frustrated when I see, I have questions when I see either a law or an MOU that seems to imply that the elder, who is the subject of an individual case review, is not allowed to know what happened in that case review or what got said in that case review. That is not a person-centered, trauma-informed approach, and it's going to make elders feel like objects who are being, like, acted upon, rather than autonomous people who have their own wishes, wants, needs, and complicated lives, regardless of what their capacity is, right? And if they don't have capacity, then they may have a guardian who is somebody who's trying to channel their wishes and needs and desires for their lives. So think about what, even if the elder is not in the meetings, what is the appropriate for the elder to know about what happened in the meeting? And then who is the most appropriate person on the team to be sharing that back with them? Really think in a nuanced way about how your team wants to use information, and then write a set of rules that makes sense for that. Because again, I see a lot of laws that or MOUs that sort of do something that isn't what folks intended, and it's not actually what they turn around and do in practice because it wasn't what they intended. But for everybody who's a professional on the team, if we think about the Vegas rule, like what happens in Vegas stays in Vegas, each professional who's on the team also has to make that judgment call about what you can bring to Vegas. So sometimes groups will use we have a Vegas rule where nothing that's shared in that room gets further shared. They think that that creates an exception to their independent professional confidentiality, and it doesn't. Unless it says so, it doesn't. So perfect example, if my 23-year-old son wants to go to Vegas, what happens in Vegas stays in Vegas. He doesn't have to tell me, but I get to decide whether he takes my car to Vegas with him. Right? He can't, just because what happens there is going to be a secret doesn't mean he's allowed to take anything he wants with him there. Same thing for professionals thinking about what they can bring to the group. It is a question of, and again, this is a tricky thing to do in an hour for a national multidisciplinary group because you're all different, right? You come from different jurisdictions, and you come from different professions. So what I'm trying to do is give you that structure for answering questions and having your local discussions and making sure you know where to go for technical assistance to get localized support. It's also really important to understand each other's rules so that you don't get frustrated or mad at each other about what somebody is not saying, or when somebody says, it's not the kind of question I can answer here. Right? So definitely, as you are working together early on, spend time teaching each other where you come from with information. Now, this involves some humility as well. So the reason I talk about information norms is because there are some folks who, for instance, the norm for victim advocates is to never share, never share, never share. And sometimes they'll express that to me as law, even when the law lets them share, because that's the norm that they have. So one of the things we can do as MDT groups is we can politely, respectfully push each other a little bit. And like, when you say you can't share that, you help me understand why you can't share that. Where does that come from? What's the reasoning behind it? Is that actually what the rule says? And if the rule doesn't actually say that, is there a different policy reason? And can we talk about whether that works for our community? Right? So really kind of having that, being a little bit vulnerable and a little bit humble about where you come from. This comes up a lot with subpoenas for victim services providers, where they'll get a subpoena and they say, we don't answer subpoenas. And I'll say, well, what does the survivor want you to do? And they're like, oh, the survivor wants us to answer the subpoena. I'm like, then you actually answer it, because the guidance, the principle, the rule that you're leading from is the survivor decides, not I keep secrets. It's the same thing in being honest and humble and willing to test your preconceived notions about how you share information in this group, so that you can get the value of coming together and the synthesis of better outcomes for elders who have experienced harm and exploitation, and for your community as a whole. So there is actually a kind of a helpful compilation of MDT statutes that was just updated in 2025. I was very excited. Thank you so much for doing that. And there's a link here. So if you are not sure whether your state has a statute or your jurisdiction or what it looks like, you can start with this hyperlink, and you guys are all going to have access to the materials, and it has that hyperlink in it. And it was still there at least a month ago. So hopefully it's there. If you have any issues with it, again, you can reach out to me for technical assistance, and we'll figure it out. So some state statutes for MDTs do allow confidential professionals to share information with the MDT team, and then they might make the whole team's communications confidential. And they also can set up some rules for information related to APS investigations. So it might create more flexibility for adult protective services to share information with the team, depending on your local law and also kind of what the team's purposes are. One thing that's incredibly important, and I can't, at this point, I'm going to get this tattooed on my forehead. MOUs are not law. MOUs are not law. They are not law. They are not law. MOUs are like contracts. Actually, they're not even contracts, really. I came up with this analogy the other day. If anybody's ever had roommates, especially when you were a young adult, MOUs are like a chore chart on the refrigerator in your shared house. What do I mean by that? I mean, it is a division of responsibilities, is an explanation of how you are going to work together and manage your space, your meeting space. However, if somebody in the house doesn't do the chore they were supposed to do on the chore chart, not a basis for eviction, and it's not they don't owe you money, and they haven't violated a contract in the legal sense, they have violated a community understanding of how you are going to be together. So that is what an MOU is. It's why it's called a memorandum of understanding. It is, we are putting down on paper our understanding about how we are going to work together, but you didn't, to get super wonky lawyer about it, you didn't exchange consideration. And so there's real questions about whether you could enforce it against someone. But there are social consequences or community consequences, maybe grant funding consequences, if somebody does not comply. But MOUs are not law. And so the reason that matters is because you cannot use an MOU to change the law. So if there is a privilege or confidentiality law that prohibits sharing, no MOU can change that. You cannot sign an MOU that gives away a legal privilege or confidentiality rule. If there is a criminal or reporting law that mandates sharing, requires that it happen, you cannot sign an MOU to take that away. All right, because again, they're not law. And I'm actually going to update the slide. I really just thought of the roommate short chart analogy like 2 weeks ago. And it is in my brain, I think it's the best description. It matters. I'm not saying it doesn't matter. If you've ever had one of these short charts, you know not doing it has major consequences in your shared house. It matters how you function as a group. MOUs matter, but they can't change the law. So here's an example, and this is a really important one because I see this a lot, where I will see sometimes an MDT statute or an MOU that says there are prosecutors and police officers involved in this team, and everything in the team will stay confidential and it will not be shared outside the team. And there is an exception to that, that is the Brady exculpatory disclosure. And no prosecutor and no police officer is allowed to agree their way out of it. So what's the Brady? Brady is just a reference to a Supreme Court case. Some states have a local state case, and so you might sort of use that shorthand. But the short version is that prosecutors and law enforcement must disclose exculpatory evidence to the defense where there is a pending criminal case. They don't have to do it during an investigation, but if there's a pending criminal charge, we're theoretically going to trial on this, someone has been charged with a crime, then you have to share with them information that tends to show that the defendant is not guilty, or that discredits a prosecution witness, this is a big one, or that reduces the seriousness of the offense, right? So remember I said we might have a big team, and it might have a primary purpose and it might have secondary purposes, and we might have some meetings for different purposes. If there is, for instance, a healthcare professional on the team, and there is a financial professional on the team, and there's a victim services person on the team, and they want to have a conversation that's kind of related to the struggles of the elder, some things that might indicate, but we're not sure, that there are issues with the elder's grip on reality or their facts or their statements, you might have a meeting that does not involve law enforcement yet, or prosecution, because once you have that meeting expressing doubts, there is a risk that that becomes a Brady disclosure if there is a prosecution later. So it's just making choices. And it's really interesting. I mean, I love my job and I get to talk to folks all over the country. And I've heard lots of different prosecutors have lots of different approaches to this question. And so while Brady is a national constitutional rule, there, and it really weighs on prosecutors quite heavily. This is a duty. It is an ethical issue. There's at least one prosecutor in Texas who was suspended from their bar license for violating Brady. So really need to have conversations with the prosecutors participating in your MDT, how they think about this question of what rises to something that must be disclosed to the defense, because then you might make decisions about how you interact and when you might have sub meetings of smaller groups. Okay. So the other thing that's really important, or the number 4 on the list, is understanding the law for each team member, which we were just sort of bridging into that with talking about the law that applies to prosecutors and law enforcement. It is, I think, your individual responsibility to make sure that each of you knows your own law for participating with the team. How does this impact me? And then make the time to educate the team. Make the time to listen to each other. I think sometimes, we do maybe a decent job of setting up sessions to be like, I want to teach you what I know from my expertise about elders and exploitation and mistreatment of elders. But also, if we're going to be on a team together, I want to teach you how I approach information. And some of that is about the law. And where it's not about the law, I'm going to be honest and tell you this is about judgment. It can be frustrating. I'm not going to lie to you, because elder abuse MDTs don't always fit neatly into the existing rules. Again, there have been more rules that are explicitly about child abuse MDTs. And so sometimes you're coming to a body of rules that haven't quite imagined you yet. And I find this a really useful thing to just acknowledge about the law. When the law doesn't imagine what you're doing, or there might be an absence, then you sort of start pulling in different pieces and making a judgment call about what you think is allowed or not allowed and how you want to move forward. Make sure when you're thinking about the law, pay attention to the difference between an investigation and an MDT activity. That this comes up if there's an adult protective services investigation and there's law about the investigation. Does your MDT fit into the investigation rubric or not? That might go back to how you designed your team, what its purposes are. Okay. And then pay attention again to requirements on disclosing beyond the MDT and prohibitions on sharing with the MDT. As you are trying to figure out how does this apply to me? Again, think about the get. How does the MDT get information? The got. How does the MDT hold information? And the give. What are the rules about giving it out? That also applies to you as an individual. Always asking the question, do I have the power to decide whether to share with this group? That is actually quite different across the spectrum of professions that are participating, and even among confidential professionals. So this is always very interesting when I talk with, for instance, APS investigators who are like, oh, we are confidential, we have confidentiality. But also under the law, APS tends to have a lot of discretion to decide to share information in the best interest of the elder or in the best interest of the investigation. Whereas a advocate, if they're functioning under federal VAWA, VOCA, FIPSA rules, does not have discretion to decide to share information because it's in the best interest. It is solely a decision of the elder that they are working with, or if that elder has a guardian, that elder's legal guardian. So that's very different, even though they will both say to me in a meeting, oh, we're confidential. And attorneys are somewhere in between. Attorneys are actually allowed to make a judgment call that their client would want them to share information to achieve the legal goals. So if you do determine that you have the power to share with the group, then you need to ask, do I think it's helpful to share with this group? And a clear, accurate MOU that describes what the purposes are and is clear about how information will get used will help each profession on the team to answer that question. So I talked briefly about attorney confidentiality. This is something even attorneys rarely articulate, but it's just sort of like baked into the fabric of how we function, that we are actually allowed to make a judgment call, even about confidential information that we think the client has impliedly authorized it. This is actually a great example of how professions have behaviors that are so baked into their culture that they often don't see and they don't know how to describe to other folks, even though sometimes if you go back to their rules, they're right there. And I say this because I practiced law for 15 years. I thought I was a good lawyer. I thought I did confidentiality well. And then as soon as I started specializing in confidentiality, I was like, wait, why do I just answer a question in court with my client's information and not check with them first? And then I went back to the rule and I was like, oh, it's there in the rule. It's impliedly authorized. But I had never thought about it. If somebody had said to me, when do you share information? I would have said, only when my client wants it. And so, again, being on an MDT is a little bit about being vulnerable yourself and having humility and saying, if I'm going to come to this cross-disciplinary group to achieve good in our community, I need to take some time to understand myself. So that I can explain myself to other people. So if everybody comes to the group with a sense of curiosity and learning, both about each other and about themselves, it helps. I know that's tricky because sometimes you come to the group with prior experiences with the people or with the profession that weren't positive, right? And so we carry that into our group dynamic. If we can try to pull back and say, I'm here with curiosity about others and about myself, because we're trying to achieve something important and urgent. Okay, so that brings us to what are your group norms for information exchange? How have you decided as a group that you are going to talk to each other? What is expected? And I've been saying this throughout, but I cannot emphasize it enough. You've got to take the time to learn each other's roles and each other's rules and practice respect for other professions. Everybody is coming from a place for a reason. Everybody is coming from a place for a reason. And their reasons might have different implications for what is a good idea to do with information. And so it's not okay to pressure or judge each other for following their ethical norms. I think it is okay to have curiosity and say, oh, I want to understand where that comes from. And I think it is okay to say, you're telling me you have to do it this way, but I'm not seeing that. Does it come from somewhere else? This comes up a lot with actually with so-called mandatory reporting of abuse, where you will have professions tell me with a completely straight face, I am required by law to report abuse of elders, mandatory reporting. And I will say, are you? And they'll say, yes. And I'll say, well, let's look at the rule. And then we look at the rule together and they're like, I'm not on it. And I was like, I know, I don't see you either. Is there a different category you fall under? They're like, no. And I'm like, okay. So I'm not judging somebody for having come into the situation thinking, I think this is a law because someone told me that, or I misunderstood, or somebody is saying, I thought it was a good idea to do it. And so I told myself it was mandated, even when I really just thought it was smart or warranted. Or sometimes people will say, I thought I had to do it. I actually don't think it's warranted. It's been frustrating for me in my career for a long time. And now I see that the rule is something different. So I can take a step back and think about what best practice looks like. But those are only possible if we are not judging each other or writing each other off, if we are creating space for information and sharing. And I think I've said this a little bit before, but I really want us to think, where does the elder fit in? So this is the English major in me coming out. If you are, at least my age, you were taught to diagram a sentence. We don't want to make the elder the object of the sentence, right? That they are the thing that's being manipulated and looked at and studied and challenged. To the extent possible, we want this person to be the subject in their own life. And if one of the goals of the MDT is to meet their needs, then we got to treat them like the subject. So is there a way for the team members to share information with the elder or their guardian or appropriate non-abusive caregiver? Maybe that's something the team needs to decide. If you don't have any law that dictates that, then the team can discuss what do we think is appropriate so that we have an understanding about what will be done. And think about ways for the elder or the guardian or the caregiver to bring information to the meeting. Again, this gets to victim advocates sometimes will tell me, well, I go to those meetings. I will say, if you go to an MDT, what do you say when you get there? And they'll say, nothing. I say, nothing, nothing. And I'm like, nothing's not the right answer, right? The legal answer is you share what the survivor you're working with has instructed you to share. So the elder has instructed you to share, or maybe the guardian or the non-abusive caregiver has instructed you to share information, you share it. So think about how that can be used appropriately within the parameters of the goals of the team. So I do recognize that an MDT, especially doing systems improvement, may be having sensitive conversations that it is tricky you don't want to think about that information getting out because you made yourself vulnerable. So that's why we got to have honest conversations about how information should or should not get shared. I do not recommend using a universal release for everyone on the MDT. So in other words, one form, one ring to rule them all, one form that says, you have my permission to share with law enforcement, advocacy, legal services, financial, medical, protective agencies. It is too broad, and the consequences, the pros and cons of sharing with each are different. And so it puts the elder, especially, in this incredibly difficult position. And it creates an implied pressure to consent in exchange for services. And too often I see these kinds of releases sought before anybody even knows what kind of interactions they're going to be having or what information would be involved. So I think that these universal releases feel to me like a CYA and something that your compliance lawyer might tell you to do, but they're not about person-centered, trauma-informed problem solving for elders who are experiencing harm. I just want to make sure you know about resources, and then we're going to look at questions. TechSafety.org is my colleagues at the National Network to End Domestic Violence, the Safety Net team. They have been working on the intersection of confidentiality and technology for 20 years, 25 years. And I partner very closely with them. We have created a confidentiality toolkit. It is very much aimed at providers who are covered by the VAWA, VOCA, FIPSA victim services provider confidentiality. So please know that that's the lens through which this is written. But there are some materials in there about how do we work together. And there's also materials about tech and how do we use tech in a way that is confidential and privacy protective. And I can already see some tech questions popping up. Please go to the techsafety.org website and the resources page. You will find a confidentiality toolkit. You'll find an agency use of tech toolkit. You will find a electronic and tech abuse evidence toolkit. Lots of really useful things. And you can always ask questions. So Safety Net at NNEDV has a grant from the Office of Violence Against Women to work with anyone who's VAWA eligible on confidentiality questions. So that's going to cover lots and lots of folks on this team on this presentation. And I am a partner with them on it. So you can email me directly and ask me a question. You can also email Safety Net. You can email both of us at the same time, and then you get the maximum number of people triaging your question and working on it. All right, so let's turn to questions that have come in.
So Alicia,
yes.
This is Shelley. We have about 10 minutes.
Okay.
I have some questions here, and I'm just going to go through some of them.
That's good.
One question is about AI and confidentiality. Any suggestions about using AI note-taking during virtual MDT meetings?
Right. So here's the issue with AI right now. It is completely unregulated. There are no rules for AI. So there is no clarity about when information gets put into the AI, whether how it is then being used by the companies that provided you the product. So I would not use AI note taking for any confidential conversations, communications, or meetings because we just don't know. It's just a flat out, we don't know. And even if the company's policy says that this is what they will or won't do, also, I guarantee you that policy says they have permission to change at any point in time. We don't know what we're looking at yet. I would love to see regulation that sort of says these are the boundaries and the parameters for using it. The folks at Safety Net are doing a lot of work and thinking on AI. I only come to the technology as I'm forced to for confidentiality questions, but they are actually tech people. So it's another reason to pay attention to their blog, and they do presentations on AI and confidentiality. I believe they did one recently, and that you can probably access a recording of that on their blog.
Okay, thank you. I know that question came up actually a lot in our listening sessions as well, so thank you for answering that. So now I think this is referring to a state where there is a statute where the district attorney is the lead agency. So what is your recommendation when the team revolves around the DA's office and they can share the name of the victim to the whole team? How should this be handled when it is uncomfortable? And I'm assuming there are some professions on the team that find that uncomfortable.
Sure. So this is a great example. Oh, go ahead. Am I good? Am I ready to answer?
Yeah, that's it.
Yeah. Okay. So this is a great example of how different professionals coming in with different information norms can have someone else do something that the other person's like, no, this feels exactly right. And I'm like, oh, this feels wrong, right? Emphasis on feels, and feelings matter. But then you have to be like, well, why does it feel wrong? So from a legal perspective, I can't think of any reason why a district attorney would not be allowed to say, this is the victim of a crime, the complaining witness, the elder that we have identified, and I want to make sure everybody knows this person's name so that you can be aware of having worked with them, right? That feels, to me, on its face, without knowing more detail, utterly legally allowed. And if you are a confidential professional, let's say an advocate, when you hear that, I think two things come up. One is that feels weird. I come from a world where we would never do that, right? So first thing is recognize you're on an interdisciplinary team. So it's going to look different. If you had the discussions in advance, hey, how do we manage information? You would have had the discussions where the DA said, this is my plan and this is why I think it's a good idea and it's allowed. The second thing I think the advocate worries about is that they're going to be asked to confirm that they're working with the person, which for a federally funded advocate and also under most state privilege laws would not be allowed. So now the discomfort that the advocate is feeling is, I'm going to be asked to confirm, are you working with the person? Do you know who they are? What have you done for them? And what have they said to you, right? These are the four things folks worry about. None of which you'd be allowed to answer unless there's a statute that explicitly says you can, or the survivor asked you to, right? So again, getting back to that, did we have conversations in advance about why am I in this room? Why am I on this team? And what is expected of me? So I really appreciate this question because it's a good material example of what it feels like if we haven't done the groundwork to say, this is who each of us is, and this is how we're going to work as a group. And this is where I understand and respect you. I can think of an example. It's not an MDT, but there's a community in Idaho where when the police call the domestic violence shelter, what they say is, hi, I know you cannot tell me who's inside of your shelter, but there is a victim that we believe is there and we want to get a message to her. So I'm going to give you a message to put on your message board. And I'm not asking you to tell me whether they're there or not, or whether she got it. I'm just trying to to do my best efforts to get the information to them. That is a perfect example of a police officer doing something that's entirely appropriate, but also saying, I recognize that I'm not asking you to give me anything back because I understand your rules. And the advocate says, sure, we can put a message on the message board, and it goes up. That is a beautiful example of a community where folks understand each other and where they're coming from, and they work within that.
Great. So we learned through recruiting a lot of MDTs across the country that there are very many MDTs in small rural communities. So this question is, how do you protect information in areas where the team members know the victims, small rural towns, which the team is discussing despite not using the victim's name for confidentiality purposes? I think that's common too.
Okay. So the first thing I would say is I have seen teams who they say, we're here to get needs met and discuss complex cases. And then they will say, but we don't use anyone's name. And I'll say, well, if you don't use anyone's name, how do you know, how does each of you know what you can bring to the table about that person? And they say, oh, we all know who it is. And I was like, then you're not doing confidentiality. Like it's just a game. So, confidentiality means protecting, identifying information about someone. So, I tell this story all the time. I practiced in Chicago, not a small community, although it can start to feel that way some days. And there is a person who had a pet. And in the legal aid community in Chicago, if you said the gender of the person and the kind of pet, every single legal aid lawyer across like 12 organizations would know exactly who you were talking about because the person had interacted with all of us and was particularly memorable, right? No name. I won't even tell you the gender and the kind of pet because I'm worried somebody could identify the person. So it's not about names. It's about are we identifying the person? So if you have a team where you are not sharing identifying information about a person, then you have decided what your team is doing, right? You've decided your team is not going to engage in deep examination of an individual complex case because that's just not possible if you can't share information. Take a step back and say, okay, again, what is our goal? What are we trying to do here? What is appropriate and safe to do here in a real way? So it might be utterly appropriate to bring some information to Vegas in order to do what you want to do there. And then can you protect the information so that you're not forced to share it beyond Vegas? So this is real in small rural communities and it's real in big communities. But it all goes back to why are we meeting and why are we sharing information at all?
Okay, I think we have time for one more question. What is your thought around a member of an MDT wanting to discuss a case that was not brought to the whole team outside of a regular MDT meeting? I think you're still wanting to talk to an MDT member, it sounds like.
I mean, so again, everybody who is an MDT member also has an independent role in the community. And I think the genius, the like explosive potential of MDTs is that relationship building across professions. So that sounds to me, unless I'm missing something, like a positive where somebody says, hey, this isn't a case that MDT is considering, but I know you now and trust you and we have a relationship and I want to talk to you. Again, in that conversation, they are now not having an MDT meeting. So whatever are the rules for the MDT probably don't apply. So they need to figure out what is appropriate for each of their professions in having this conversation. But they're probably coming to it in their independent roles.
Okay, we are out of time, unfortunately. We could talk forever about these issues. Thank you so much, Alicia, for educating us. And as you know, there's going to be a session this afternoon, so you're welcome to join that session as well. And we're going to take a 5-minute break now.